Good evening and thanks for joining us for the December Labour Law Monthly Update. We start with a few amendments that have come in. The first one is under the Employees Provident Fund Act. The Employees Deposit Linked Insurance scheme has been retrospectively amended with effect from 28th April 2024. As a result, the benefits under the scheme have been increased to 2,50,000 and 7 lakhs being the maximum and 2,50,000 being the minimum. As against the earlier ceiling of 6 lakhs, it has now become 7 lakhs. In addition to that, the requirement of being the same employer for last 12 months is also being done away with, but it's just that you should have been a member of the scheme for 12 months period. The Kerala government has amended the Kerala factories rules and providing for factory license up to 10 years. So in one single go, you could get a license for run a factory for up to 10 years. And earlier it was 5 years. The ESI Corporation has now got a good portal, online portal through which submissions for maternity benefit claim, sickness benefit, and all claims can be made. So circular has been issued to the branch offices to ensure that all submissions are made online and offline. Physical claim submissions should stop. Again, similarly, the UAN seeding and linking the bank accounts of the individuals through the UAN to the bank accounts is also become a mandatory requirement under the EPF Act. The submission of the annual report by 28th of each year. Again, they've been sending this again and again. The Gurgaon government has been very active on this and warning employers about the penal consequence if they don't file an annual report. The quiz question for the month is, can an employer enter into an agreement with an employee or the legal heirs of the deceased employee under the Employees Compensation Act 1923 to pay compensation? Please do key in your answers into the chat box, and we will be discussing this at the end of the presentation. Across the globe, we are looking at a law in California, which for the first time brings in what's called as intersectional identities. Already there is a law which provides for any kind of prohibiting discrimination and harassment from the time of hiring and promotion, still termination on those grounds. And to that, they've added this new terminology of intersectional identities, namely, for instance, the example that has been given is about African Muslim or Asian female. These kind of where, there are two intersectional identities coming in. Such kind of discrimination is also to be part of this law, and therefore all employers are required to update their harassment policies. In Spain, currently the requirement for disciplinary proceedings of a prior hearing was not there in the event of an employee committing a misconduct. But now the Spanish Supreme Court has said that all allegations should be made known to the employee, and only after the proceedings are initiated can the employee be dismissed from service. Even thereafter, it's only a question of compensation, and it's not like the Indian system where you can reinstate the employee. An interesting fact that we thought we would share is Section 11 of the Industrial Disputes Act empowers the judge of a labor court or tribunal to enter the premises of an establishment for conducting inquiry. So if there is a dispute pending before the labor court or tribunal, the judge concerned can visit the site or the premises of the concerned industrial establishment to ascertain firsthand as to the nature of the dispute and what is the kind of relief that is being sought for. This is a case flowing from the Karnataka High Court where the employee is found to have been stealing oil sachet from the hotel premises. After inquiry, he was dismissed from service. The Labour Court directed reinstatement, holding that the punishment was very harsh, given that the embezzlement was a very small valued item and it was very trivial. But the High Court said, irrespective of the value, it is more the conduct. So if there be a theft, certainly a punishment of dismissal is justified. This is a case of where the employee was treated as having abandoned service. The employer sent out communications asking the employee to join back work and that he's been absenting. The employee did not reply back in any manner, and therefore the employer, without any formal inquiry, treated him as having abandoned service. High Courts directed the employee to be reinstated. The termination was held to be bad, but the Supreme Court reversed it and found that the action of the employer was justified, given that the employee's non-communication and also the fact that the regulations of the concerned corporation provided for it. In the Knowledge Corner this month, we are looking at rights of a workman for assistance in domestic inquiry. So when there is a charge of misconduct that is being laid against an employee, what in common parlance is called as a domestic inquiry is conducted. The management is normally represented by a management representative. The employee defends his interest. And in addition to it, is also given the benefit of an assistant being there. So questions have arisen over the years as to who could be this person. Does he have it as a matter of right to bring a representative along with him as a defense representative? Should the employee be informed of it, or is it for the employee himself to know about it and bring? Wherever there is a provision in law, the employee should be informed about it. Primarily, if you look at private employment, it is from your certified standing orders or model standing orders. And if it is otherwise in service law, the regulations. So what does your regulation provide for? Does it provide for an assistant to be, it's a co-employee that can be brought in? Does it provide that even a union leader can be brought in? Who can be brought in? It's all to be depends on the standing orders of your company. In this case, the workmen were dismissed from service after inquiry. The validity of the inquiry were challenged on the ground that they were not permitted to bring an advocate or trade union leader, but however, they were permitted to bring a co-worker, which they did not bring in, and the inquiry was conducted ex parte. The Supreme Court held that there is no absolute right to demand either an advocate or member of a union should be allowed to defend the interest of the workmen. And accordingly, it held that there's no right for the workmen to seek assistance. In another case, similarly, also the same questions arose where the employees refused to participate, resulting in ex parte findings. Even then, the inquiry was held to be fair and said that they cannot, as a matter of right, seek for assistance of an advocate or union. In this case, the question was, the management was being represented by a legally trained person, and therefore would the workman be entitled to bring somebody who's legally trained? Ultimately, considering the facts, despite analyzing all the various Supreme Court judgments, the court had held the employee would be entitled to bring in because the management is being represented by a legally trained person. This is a unique case where, on the ground that the person concerned was handicapped, he was allowed to bring in assistance. Such cases have also been there in courts. Can you bring in a retired employee to defend your interest? Courts have said unless your regulation or your standing orders provides for it, a retired employee cannot be brought in to as a defense representative. Similarly, question of unauthorized absence, the management said you don't need a defense representative. They said it is. The High Court upheld it, saying unauthorized absence is not some technical misconduct. The employee concerned would be the best person to explain as to why he was unauthorizedly absent or whether he was unauthorizedly absent or not, etc. And therefore held that the question of the employee seeking a representation on his behalf or a defense representative would not arise. There are also standing orders which provide only for observers. So if you look at certain standing orders, it will not provide for defense representative, but only observers. Co-employees can be brought inside to only observe and maybe assist the employee. So, but he cannot participate. He cannot cross-examine management witnesses. He could assist the delinquent employee. So certain standing orders provide only for observers. So what you would need to see in all these cases when such a request comes is what does your regulation or standing orders provide? That is the basis, and you would need to decide based on that. Moving on to our POSH segment, we are looking at a case where the employee was dismissed based on the recommendations of an IC after due inquiry. The employee raised a dispute under the Industrial Disputes Act, and it was numbered by the Labour Court. The management filed their counter statement pointing out that he has a right of appeal under Section 18, and therefore the dispute is not maintainable. The employee thereafter went on to file an appeal under Section 18. The management pointed out to the Labour Court, the employee having filed an appeal under Section 18 cannot maintain the dispute under Section 2A. In other words, he cannot maintain both an industrial dispute as well as an appeal under Section 18 of the POSH Act. Labour Court opined that he could maintain both because there is no statutory prohibition. But the High Court deferred and said that no, he cannot maintain both. He can maintain only one, only the appeal under Section 18. Coming back to our quiz segment, the answer for is yes, you can enter into agreement. Section 28 provides for it, but such an agreement would need to be registered. The last segment for the day, the complaints calendar for the month of December has been there. We will also be sharing this PPT with you, which could help you. We would next be connecting on 6th January at 5 p.m. In the new year. Thanks for joining us and hope to see you all in the new year. Thank you.